Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. The first case which I would like to report today is regarding the qualification of primary school teachers. The qualification for a primary school teacher is basically a diploma in elementary education. In this case, the issue before the apex court was whether Bachelor of Education, that is B.Ed degree holders, can be appointed as primary school teachers or not. The Supreme Court has granted temporary relief to B.Ed degree holders in Chhattisgarh by staying an order of the Chhattisgarh High Court, which excluded B.Ed candidates from the recruitment process for assistant teachers. The High Court, while excluding them, had relied on the recent Supreme Court judgment in Devesh Sharma versus Union of India, which held that B.Ed candidates were not eligible to be appointed as primary school teachers, as the qualification prescribed for the said post is diploma in elementary education. The background of the case is the advertisement to fill up the posts of around 6,000 assistant teachers was issued in May this year. The exam was conducted in June and the results were declared in July. The petitioners were included in the list of successful candidates. Further, the Supreme Court's judgment in Devesh Sharma was delivered in August. Following that, few diploma in elementary education candidates filed the writ petition in the High Court seeking to exclude B.Ed candidates. And the High Court passed an interim order putting the further recruitment process in abeyance with immediate effect. Challenging the High Court order, the petitioners approached the Supreme Court. They contended that the High Court misconstrued the Devesh Sharma judgment and erred in applying it with retrospective effect without taking into consideration the doctrine of prospective overruling. They also cited the case of Assam Public Service Commission versus Pranjal Kumar, where the apex court had held that the norms existing on the date when the process of selection begins will control the selection, and the alteration to the norms would not affect the ongoing process unless the new rules are to be given retrospective effect. Based on these arguments, the Supreme Court bench comprising Justices A.S. Bopanna and P.K. Mishra stayed the High Court order. As you know, recently Supreme Court published a handbook on combating gender stereotypes containing a glossary of inappropriate gender terms used in legal discourse with a list of alternative words or phrases that should be used. Now, senior advocate Indira Jai Singh has written a letter to the CGI drawing attention towards sexist behavior faced by women lawyers at the bar and in law offices. She has thus called for a handbook on gender stereotyping, specifically addressing the manner in which male colleagues must interact with their female counterparts. In her letter, the senior advocate has mentioned various instances of subtle gender biases in courtroom interactions, from patronizing remarks to being referred to informally. For example, remarks like, "You are an empowered woman, who can put you down?" She also states that she had been asked to not raise her voice in court, and that some of her male opponent lawyers refer to her as she and never as "my learned friend," as is the tradition at the bar. Apart from this, the senior counsel has also raised concerns about the issue of sexual harassment faced by lawyers who are women in courtrooms and law offices. She points out that despite a Supreme Court directive, institutions, including the Bar Council of India, have yet to declare sexual harassment by lawyers as professional misconduct. Thus, Jaisingh has urged the Supreme Court to develop a handbook specifically addressing gender stereotyping targeting lawyers who are women. This handbook would, among other things, offer guidelines for male colleagues to treat women fairly in court and in law offices. In an important ruling with respect to the NDPS Act, the Supreme Court has observed that if the accused were not informed about their right to be searched before a magistrate or a gazetted officer, it is a violation of the safeguard provided by Section 50 of the Act. In this case, the accused were convicted by the trial court under Section 20 of Narcotic Drugs and Psychotropic Substances Act of 1985. Their appeals were dismissed by the Allahabad High Court. The accused served the entire substantive sentence of 10 years rigorous imprisonment and a sentence for a period of 6 months in default of the payment of fine. In appeal before the apex court, it was contended that the appellants were not informed that they have a right to say that their body search should be conducted before a magistrate or a gazetted officer. The court referred to the judgment in Vijay Singh Jadeja versus State of Gujarat, where a constitution bench had observed that insofar as the obligation of authorized officer under section 50 of the act is concerned, it is mandatory and requires strict compliance. Failure to comply with the provision would render the recovery of the illicit article suspect and vitiate the conviction if the same is recorded only on the basis of the recovery of the illicit article during such search. Accordingly, the court said that their conviction could not be sustained and ordered that they shall be forthwith set at liberty. Various videos were circulated on social media yesterday showing clashes between police and lawyers in UP's Hapur, also showing police resorting to lathi charge. The Bar Council of Uttar Pradesh declared a statewide strike by advocates today to protest against the police attack on lawyers. So, lawyers were actually protesting peacefully against the filing of an alleged false case against advocate Priyanka Tyagi in the Hapur district. However, the police purportedly lathi charged the lawyers, due to which many advocates sustained minor to severe injuries. The council thus called for a strike and has also urged the government to take action against the errant police officers and to provide compensation to the injured lawyers. The council has further decided that if effective and meaningful action was not taken, then an emergency meeting of the Bar Council of Uttar Pradesh would be called on 3rd September to discuss the further strategy. Also, taking note of the police action against lawyers, the High Court Bar Association Allahabad also declared yesterday that it would abstain from work today. In another update, a special court in Haryana's Gurugram has framed charges against 8 journalists for allegedly airing morphed, edited, and obscene videos of a 10-year-old girl and her family and linking the same to a sexual assault case against self styled godman Asaram Bapu. The accused include anchors Deepak Chaurasia, Chitra Tripathi, and Ajit Anjum. They have been booked under various provisions of IPC, IT Act, and the POXO Act. All 8 have been charged with hatching a criminal conspiracy whereby agreeing to prepare a forged video of a minor girl victim aged about 10 years and her family by showing the victim and her family in an indecent manner and telecasting the same on news channels, thereby harming the reputation of the victim and her family. The charges were read over to the accused, to which they pleaded not guilty and claimed trial. The matter will now come up for hearing on 25th September for evidence of the prosecution. Stay tuned with us. In another update, the Orissa High Court has upheld the conviction of a brother for repeatedly committing rape on his 14-year-old minor sister, which resulted in her pregnancy. Ironically, the single bench of Justice Sangam Kumar Sahu pronounced the verdict on Raksha Bandhan in open court. The matter pertains to an unfortunate incident from the district of Malkangiri, where the appellant, who is elder sibling of the victim, kept sexual relations with the victim repeatedly for over a year and threatened her not to disclose the same before anyone. The matter came to light when she got pregnant and informed her friend about the same. He was then charged for the offense of rape, and also POXO was involved as the victim was a minor at the time of the incident. The trial court then convicted him, against which he approached the High Court. The High Court termed the incident to be unfortunate and expressed shock that a brother who is naturally entrusted with the duty to protect his sister has not only committed sexual assault on her but also impregnated her at such an early age. The court also said that delay in lodging FIR in such cases should not be viewed with a blind eye, especially having regard for the nature of relationship that the victim and the appellant shared. It held that it is quite natural for the victim to think twice before approaching the police, as it would not only hamper her self respect but also bring endless trauma to her. The court was also informed that the victim had now married somewhere else, and the child, who took birth out of such sexual assault, had been placed under the supervision of an agency. The Allahabad High Court, in a case for interim maintenance, has held that a minimum amount must be paid to the estranged wife from the date of the claim to preserve her life and liberty with dignity. In the present case, the wife filed an application under Section 24 of the Hindu Marriage Act for maintenance before the family court, and the court awarded her an interim maintenance of 7,000 rupees per month to sustain her and her three children. The husband challenged the order of the family court before the High Court, contending that the maintenance was excessive and also alleged adultery on the part of the wife, while his real brother was the adulterer. The bench, comprising Justice Sumitra Dayal Singh and Justice Rajendra Kumar, noted that the husband had been working with IDBP, getting a monthly salary of rupees 40,000. The court observed that adultery with the husband's brother was not enough ground to assail the order of interim maintenance, since there were three children of the husband who were living with the estranged wife, and she did not have any independent source of income to sustain the four lives. The court has held that minimum amount must be paid to the estranged wife from the date of the claim to preserve her life and liberty with minimal dignity. And lastly, the Kerala High Court has held that recalling a witness under Section 311 of CRPC must be done only when there is a strong and valid reason to do so, which should be recorded by a competent authority. Section 311 states that any court at any stage of any inquiry or trial can summon any person as a witness or recall and re-examine any person already examined. In this case, the petitioner was the second accused in a robbery case. The only eyewitness was the complainant, who identified the first accused and failed to identify the second accused. The complainant preferred an application to recall and summon her again under Section 311, so that she gets another chance to identify the second accused. This was allowed by the magistrate and was under challenge before the High Court. The petitioner contended that the prosecution could not ask for re-examination of the complainant to overcome the inherent weakness in their case. It was argued that the intent of Section 311 was not to give unfair advantage to the prosecution. The High Court found that during the examination, the first accused and petitioner were present in the box, and the complainant identified the first accused alone. The court held that the power under Section 311 of CRPC must be exercised judiciously with the object of discovering relevant and true facts for obtaining proper proof. The court noted that witnesses must not be recalled to the disadvantage of the accused or to cause serious prejudice to the defense. Thus, the court said that the application to recall the complainant was not justified. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us.